But I got shit to lose, so I can't go around acting a fool. But if y'all read the rules, a big bro got the tool and he let that shit go like a boom. So man coming up soon, so y'all got to stay tuned. Big body, so y'all better make right. Ain't no wishes, but I ain't knock his down. Cooking shit up without a frying pan. Looking scripts on my director shit, but I'm new enough to be casted as an extra man. Girl, moonwalking and I'm smooth walking to the top, you bitches lose.
But so much you can do.
And I got it to try, trying to multiply cash and division of rapid. Put it together and now you have it. That's what they like, the simple mathematics. They ain't supporting, but I ain't mad at it. Don't need a stuff before I'm trying to be.
Push it forward. Forward. That whole blue side is showing right there. This is like making me mad. Yeah, I'd rather that other side show than this blue side over here because it's real messy over here. We're gonna have to work on that. Yeah, but the desk can be moved back. We can't do it right now though. When I draw my shit, pep don't make it hold down. Till I'm gon' wrap it up like a scar. I'm the life forever like a star. No, we can cut, we can go. But I don't go with them, these presidents, not up to par. And I know that I'm gon' make it far. I'm the target, they throwing my darts. I'm a beast when I show my teeth, these bitches scaring, got them thinking I'm a shark. Hello everyone, welcome.
Hello.
We're here again with our podcast, Beyond Reasonable Doubt series, and this is our 5th show. My name is Cynthia, and
My name is Shakira.
Shakira is here to give us our mission statement. And go ahead.
Beyond Reasonable Doubt is a visual podcast series focusing on the legal system as it impacts and infiltrates our everyday existence. The mission is to free our minds through sharing knowledge and experiences in order to promote awareness,
Yes.
inspiration, and self-love.
Thank you, ma'am. Thank you so much for your
You're
contribution.
welcome.
And now, I guess Mr. Twin is going to join us. He's playing technician today, but he's coming back to be our co-host as usual. And I'll just let you know, if you haven't been tuning in to our first set of shows, I'm a practicing attorney in the state of New Jersey. Hamid, who is going to sit down now. Hello, Hamid. How are you?
Good evening.
We met through this legal system very long ago, and we've been friends ever since. So, as the mission state indicates, we're here to share my legal knowledge along with his life experiences and my life experiences and everyone else who's here to try to get an understanding of how this legal system works and give you a little bit of information. So we're still in the raw because we still have an internet issue. Despite assurances that it was going to get fixed, it's still a problem. And we're trying to work that all out. So if you see any glitches along the way, please forgive us. Also, all of our recordings are going to be on our recorded episodes are going to be on our YouTube channel, and it is Bird BYRD podcast, and you can go on there to see all of the recorded videos that do not have glitches. Those should be clear for you to hear, although the live that we're doing right now, because of the internet issue, may have some pauses and glitches. But we hope you'll stay tuned because we got a lot of information to share with you today. Today we're going to be talking about social media and its legal ramifications in terms of incriminating yourself with your social media post. But before we move on to that, last week we talked about child support, and I had a couple of cases that I did not share with you. So one thing that I wanted to mention is that there are situations when people on child support and they have to go to prison and serve jail time. So the question is, what happens to your child support when you're supposed to pay but you're locked up? Do you know, Hamid?
it keeps going, I believe. I believe it keeps going until you put some kind of motion in to explain to the judge a situation.
What does that mean? You talking?
They keep talking a little bit louder.
Oh,
Oh, Hamid has to talk, but can you let us know out there in social media land if you cannot hear one of us. And we could see you, but it's kind of a somebody's telling you to wake up. Wake up. Damn. Candy.
Yes, too.
Wake the hell up.
I'm up, Tone.
Okay. So you're right. They what happens is your child support continues to accrue, meaning that it still piles up, and you have to pay the arrearages. But if you file a motion to stay the proceedings due to your incarceration, then your case could go on the inactive list. Even though it's still going to accrue, when you come out, you can make your argument that your child support should be decreased because of your incarceration. So in New Jersey, there's a case that you can look at to find out this information. It's Sanzari, Sanzari versus Shabazz, Shabazz. And this was a decision that was decided in the Appellate Division of the Superior Court of New Jersey, March 4th, 2010. The docket number is A-2870-08T1. And it tells you about this particular person's case, but it cites to other cases that indicate what can be done if you're on child support and you get locked up. So the main case, I believe, that you should read, and all of these cases you can Google. They're online, and you can read them for yourselves. If you could read the Bible, if you could read the Quran, or if you could read a chapter book, you could read these cases, and it's important. So you need to I'm not trying to tell you what to do, but I'm just telling you the information is available for you. So Halliwell v. Halliwell, Halliwell, Halliwell v. Halliwell. And that's at 326 NJ Super 442 Abdiv 1999. I think that's the one of the leading cases on the issue. And there's some more cases that that they mentioned in the in that case for you to look at. So also, this as an aside, there's a case that came down in a Supreme Court case that came down in 2017. It's called Packingham v. North Carolina, and the site is 137 S-CT, that's the Supreme Court, 1730, 2017. Packingham v. North Carolina. It's Packingham v. North Carolina. You guys know how to spell North Carolina. And basically with this case, it addresses the issue of people who are on supervision, parole supervision for life, and restricted from the use of the internet and social media. Essentially, the case is saying that if there's a strict ban from your use of the internet and social media, that is a violation of your constitutional rights. So this is off topic, but I ran across it, so I wanted to just share it because it's new law, relatively new, 2017. And I think that a lot of people who are on supervision for life or under some type of strict supervision, they may have their access to the internet restricted. Well, this case that came down says that a complete ban is no longer going to be allowed, as it violates the Constitution. Maybe I'll get into this case at another time, but again, you could look up the case yourself. It's online. It's a Supreme Court case. It's Packingham, Packingham v. North Carolina. And the docket number is, it's 137 Supreme Court S.CT. 1730, and the year is 2017. So look it up if it applies to you or if it could be helpful. So now we're going to talk about social media. Now, I'm going to start out with wiretaps. I know that everybody is familiar. Well, I ain't sure, but a few of you may be familiar with wiretaps. Well, Hamid says he's familiar with wiretap. Do you want to share what your knowledge is about a wiretap and how that works in the criminal justice system?
No, I just know I was involved with a wiretap.
Okay, well, without getting into the specifics of your case and not naming no names, what was the wiretap all about? Like, what is a wiretap?
It's basically concerning criminal activity, and.
But what is the wire that's being tapped? It's on over the phone wire. Like some people don't know what it is.
Our text messages, voicemails. They was able to get all of that.
So the wiretap statute is a federal statute. You could look it up if you want. It's 18 U.S. Code Section 2518. You could look up on the online and find out what a wiretap interception requires, because the government has to ask permission to have someone's phone tapped to listen to conversations. So this section 18 U.S. Code Section 2518 tells you what has to be done by the FBI, because they're usually the agents that do this, this is federal. The same applies to state. Each state may have different. This is hold on one second.
Why would you share it?
I don't, because it stopped.
The internet stopped me from continuing.
Okay, hold on though. Hold on, we pausing 1 second, guys. Because you think mine is not on. Hi, guys, we're back. Sorry, we got interrupted from the live on BYRD podcast on Instagram, but I have it back on. So anyway, so there's certain things that the government has to do before they can get permission from the judge to listen to your telephone conversations, and that is federally and state-wise. They can't just the police, the detective, the who is the FBI agent, the government, who is the AUSA for the federal. Mm-hmm. They have to ask for permission to listen into your phone conversations. So
based on probable cause.
Based on probable cause. Now, do you know what you want to tell me what probable cause is?
No, you could.
Okay. Probable cause. Probable cause is defined as and you could look this up too, people. I didn't make this up. Probable cause is a requirement found in the 4th Amendment of our Constitution, and it must be met before the police can make an arrest or conduct a search or receive a warrant. So basically what has to happen is the court, an application by a law enforcement officer is given to the court, to a judge, and the judge has to find that there is a reasonable basis for believing that a crime may have been committed for an arrest, or the evidence of a crime can be found in a particular place, like your house, your car. So reasonable basis for believing that a crime has occurred or that criminal proceeds can be found in a place. They have to put that in an application to the judge, and the judge has to determine that yes, there is a reasonable basis to believe that a crime has occurred or that there is evidence that can be found at a place, and therefore the probable cause requirement has been met, and therefore you could have your application for your search warrant. And by the way, when the police come and to your house and they show you the pink, it's pink in New Jersey for the most part. There's some white ones. That is not the search warrant affidavit. That's just the end of it. That's just the paper that you see saying that, yeah, we have a right to come into your house. But the search warrant affidavit is what the officer applies for in order to get that pink sheet or that white sheet.
But the pink sheet is appropriate to give to the...
That's what they're supposed to give to the person who is either being arrested or the person whose house is being searched. or the person that they're looking for. Somebody's supposed to see that piece of paper. Sometimes you don't, but it's supposed to be shown. But
And if it don't, is it an argument?
it really doesn't matter too much.
Isn't like that's
In
like a
reality,
receipt.
it doesn't matter too much, because what they're going to look at is the application that the officer submitted to the judge, and the judge saying yes, you could enter that house. The judge's order saying yes, you could enter that house. Yes, that person can be arrested. That's going to be the factor that is determinative, not whether or not you saw a piece of paper, because the officer is going to say, perhaps, I'm not putting no words in nobody's mouth, but the defendant, who is the person, the suspect or whatever, who's on the other end of this, can say, oh, I didn't see it, and the officer says, oh yeah, I showed it to him, and there you are. There's nothing after that.
He just say what he's saying, and there's really no truth to it.
So what you saying that as if it were something that you would be surprised about, or you could fight?
No.
What would be your proof? What would be your proof that it wasn't shown to you?
What is it any proof that he really went and got a search warrant, and he just telling me that when he really never got one?
Well, the search warrant, there's going to be proof in the police file, because the judge's order saying that this can happen is going to be there. Now, whether or not you got a copy of something is really neither here nor there, because they're going to have their records that the judge said okay.
No, so say if an officer just using the tactic just to get in your house, he never went through the procedure at all.
That's unlawful.
We know that, but
Okay.
How could you prove that to a judge?
Well, you're gonna have to. He needs a battery.
No,
I mean,
oh.
So the once you get to, you're gonna get arrested. So you're gonna get arrested, and you may or may not get your Miranda rights read to you. We already talked about that. They're supposed to read your Miranda rights, but maybe they will, maybe they won't. And then once you get processed and you go through your case, then they're going to have to produce the affidavit that they gave to the judge to try to get into your house, and the order that the judge gave them saying that it was okay.
Is it mandatory for them to read you your Miranda rights when they arrest you?
They're supposed to read you your Miranda rights, but like we discussed before, if they don't read you your Miranda rights and you don't give a statement, then it really doesn't matter. Miranda rights go to statements.
Yeah. So if you gave a statement, they never read your Miranda rights, and you give a statement, it's
unlawful.
Unlawful. You could fight that.
You could fight that.
Right.
So now, but today we're talking about wiretaps. So once there is probable cause to, and the probable cause is the totality of the circumstances, which is one of those broad terms, just like the harassment. It's like whatever factors put together, and the judge determines that it's probable cause. So an example of that would be, okay, well, the officer says he observed a drug transaction. He observed the individual selling the drugs, go inside his house, come out, make a drug sale, go back in his house, and then do that a couple of times. And then there's an undercover, not a CI cell, confidential informant, makes a buy from the house or whatever. These are factors. So that all goes into.
But probable cause could be anything in the way the police.
Well, it can't be anything. It can't be like somebody just called me up and said something was happening at a particular location. There has to be factors. So if they have the CI making the undercover, making the buys and all of that, they put that in the affidavit, and then that provides the judge with the facts and the totality of the circumstances to issue the warrant to go in your house. Now, if all this stuff took place outside of your house, then there may not be a sufficient cause to go inside of your house. But we could talk about search warrants and all that later, because right now we're talking about wiretaps. So you have to have probable cause. The officers have to have probable cause and present an application to the judge to be able to listen in on your phones. Now, once they're allowed to listen in on the phones, they have to put a particular number in there. So if they wanted to listen to me, they'd have to put in my particular number in the application to to get the search
When you
warrant.
say number, you mean your cell phone?
My
or
phone
your
number. So it'd be
number?
973-725-4300. They got to put that in there. They can't just say any phone that Cynthia's on.
And the way they will be able to get that number is by the CI.
Through whatever investigation, they got my phone number. 9 times out of 10, it's the CI involved, a confidential informant who gives up information to the police. That's how the whole investigation can get started on a wiretap. So and so at this phone number is selling drugs, and we have probable cause. It can't be just that. We have probable cause to believe that we could get more information that will help us in our investigation if we're allowed to listen into the phones. So they have to have probable cause. They also, for a wiretap, have to show that there's no less restrictive means there to get the information that they're seeking. So if there's another way that they can get the information to help their investigation without going through your phones, then they got to do that first. This is just on the wiretap.
So, is it?
I'll read it to you right now, just in case I'm confusing anybody. If you go to this code, this is the U.S. code. This is a federal code. So they tell you that there has to be an application. The officer has to identify himself. This is A. This is 1A. The identity of the investigative or law enforcement officer making the application has to be known. So we have to have the officer there. You have to give a full and complete statement of the facts and circumstances relied on by that officer. So whatever they did up until this point where they're asking for this wiretap, they got to tell the judge. A full and complete statement. Now this is C. You see it on 1C. A full and complete statement as to whether or not there are other investigative procedures that have been tried and failed, and why they reasonably appear to be unlikely to succeed if tried or to be too dangerous. So that's an extra element that's not required in a regular search warrant. In a wiretap, they got to show, I'm going to read it to you again. Anybody who got a wiretap issue, and I'm not giving you no advice, even though I'm a lawyer, this is just a general discussion. I'm not giving nobody any advice, but it's right here in the statute. If you look it up, it's 1C. It says a full and complete statement as to whether or not other investigative procedures have been tried and failed, or why they reasonably appear to be unlikely to succeed if tried, or to be too dangerous. Okay, so
Explain that part to them.
okay, so say for instance they want to listen into your phone conversations, but there's another means by which to get information as to, I'm just going to just keep it real simple, as to the color of your car. So they go to the judge like, we need a wiretap because we want to know the color of Hamid's car, and we need to listen into his phone conversations to get the color of his car. So the judge will probably say, well, why can't you just follow him to his house and see what he pulls up in? Or why can't you go to the DMV? And it's not the DMV anymore, is it? I keep calling it. No, it's the Motor Vehicle Commission. It's the MVC.
No, it's
but
DMV. Department of Motor Vehicle.
It's the Motor Vehicle Commission now, isn't it? Somebody out there know? Okay, I thought they changed the name. Anyway, so the judge will say there's a less restricted, well, I shouldn't say restricted. There's a better way to get this information rather than to tap this man's phone. So either you go and you follow up to his house or do an investigation to see if you can get the color of the car he's driving, or you make a query with the DMV and see if the car is registered to his name. So if they come back and say, okay, judge, we tried all that, but the vehicle there's no vehicle registered to him at the DMV, and we can't go to his house because he's going to find out that we're following him. So then the judge might say, oh, okay, well, you tried everything that you could do, and following to his house is going to be dangerous for you. So yeah, you can get the wiretap and listen to his conversations to find out about the color of his car. That's a simple way.
Now, is that an option that the judge normally use?
I don't know what the judge does because I ain't never in when they do the application. It's just the judge and the police officer.
But you did wiretap before.
I've handled wiretap cases. Yes, I have.
And when you got that application, was that an option that the judge gave you?
Normally in the wiretap application, it will say the statement, judge, or the statement will be, we tried X, Y, and Z, and we weren't successful, and doing it any other way will be dangerous to our revealing our identity, or it'll be a danger to our investigation. The investigation get blown up. So that's what would be in the application. So if you want to challenge, and you should always challenge the application for a wiretap, because it's just like challenging the affidavit for a search warrant.
Yeah.
It's the same thing, but it's pursuant to federal law. This can happen. It says, and you also have to ask for. There's a whole bunch of stuff here, and you guys, you can look at it yourself. Where the F is, where the application. Oh wait, no, I'll go back up to E. Well, they got D, they got E.
And they might as well just.
Yeah, they got a whole bunch of stuff here that they have to do. They have to put the time period. They have to talk about any previous applications that have been granted to other people on the phone. They have to do all of that. Now, if they get the application for your phone number, my phone number, 973-725-4300, okay? And I decide that I'm going to be smart and get another phone and change my number. Just because I do it every week, because I don't trust nobody. So I just get me a new number every other week. Well, that ain't going to help me, because they have what they call a roving wiretap. So that means that if your number is tapped and you change your phone, that wiretap application rolls over to the new number.
But to the new number that you changed on that phone that you changed the number on?
No, whatever new number that you have now. You know, sometimes people will think that if they get rid of their one phone that they set a bunch of stuff on, and the end game is talking on the phone probably wouldn't help you criminally if you are the type that tends to talk a lot on the phone about your business. But people think that if they throw away one phone and pick up another phone and they buy these throwaways, that's going to end the problem. That doesn't end the problem. So the case that talks about the roving...
and when did this come out? This rollover thing?
It's been out. So I'm going to refer you to this case. Now, this is New Jersey. This is not federal. The first statute that I referenced was a federal statute, but this is a case that talks about the roving warrant, and it's called Feliciano, Feliciano v. Oh no, State of New Jersey v. Feliciano, Feliciano. First name is Hector, and this is a Supreme Court case. It was decided in March 9 of 2016, and the site is 224 NJ 351, and the year is 2016, and it talks about the roving warrant, and basically whether or not the officers have to get an entirely new warrant, or can it apply to the new number. And essentially the officers have to do a couple of things, but essentially it can roll over to your new number.
New number, new service, and everything, because they might have went to Sprint.
What it can roll over to whatever new number, wherever it is. There's no caveats between whether it rolls, if you were a Sprint and it rolls over to Verizon. Oh, there's no rule or stipulation or requirement. It seems like I keep saying requirement. That says that you could only roll over from a Sprint to a Sprint or Verizon to a Verizon. That's not it. They talk about the new numbers, and.
Well, I thought they would have to go to get another application for that particular service that you got now. You had Sprint, now you went and got another service.
They don't have to get a new application from the judge. They'll have to let the new telephone server know that they have a search warrant, because that if it's Verizon and the other one was with Sprint, then Verizon don't know, but they're going to send it to a Verizon, but it's still going to be the same connected application.
All right, now do that particular service has to comply with that application once it's being submitted to them?
They will. I don't. If it's
once
a court order.
Provided to them?
It's a court order. Yeah. You have to comply with court orders, and
all phone services have to comply with court orders.
Everybody, every company, every person, you have to comply with a court order. And Sprint or Verizon has no reason to. They're not going to get in the middle of nobody's beef. If the court says that they got to turn over information, they're going to turn over information.
I'm just asking for the people because this question is.
Oh, if that's a question for the people, yes. Verizon, Sprint, all of them, they're going to definitely comply with the court order to turn over the information. Okay. So now...
Is Carlos tuning in, Andy? Is Carlos tuned in on this today?
Carlos don't want no part of this.
Nah, I don't hear him tuning in. Don't we got a number or something like that?
No, we ain't got Carlos' number.
Don't we have a number?
Oh, we do have a number. We do have a number, 973-877-3737. That's the call-in number. Now,
would it be this one to the left?
Yes.
All right.
So, now, the thing about the applications for the search warrant is that once one phone has gotten, then the officers, whoever's intercepting law enforcement, gets to listen to all the conversations that person has with everybody on his phone, or her phone. So if you got, like, say for instance, Hamid, you call me and we have a conversation, and it's nothing incriminating in our conversation, and I decide to call Shakira.
On three-way?
No,
oh.
I hang up with you.
Yeah.
I call Shakira. So I start talking to Shakira, and I say, oh yeah, I was just talking about with Hamid, and me and Hamid gonna do ABC, illegal activity stuff, and I wanted to know if you wanted to be a part of it, or you want to, do you have anything or whatever, and I bring her into whatever illegal thing that me and Hamid got going on. She's in too. So the wiretap is kind of tricky because Hamid don't even know that I'm talking to Shakira and running my mouth about his business. Yeah. But that's the nature of the wiretap, because whatever he says, if I implicate myself, they can go get a warrant for my phone, and then now they listening to me talk to her about Hamid.
So now you got two wiretaps.
You got wiretaps going everywhere. One person, and usually in my experience, because I've dealt with a few wiretaps, the one wiretap initiator is that person that you know always running their mouth. I can always tell how the wiretap got off by the conversation, because that person talks about any and everything under the sun, and they have no discretion. So, not that I'm not telling you how to conduct your business, and I'm not trying to give you an idea about how to talk on the phone. That's not what I'm talking about. I'm just trying to tell you how these wiretaps work, and they can spread to the people, and that's why if you know about a wiretap case, or you ever been caught up in a wiretap case, it's usually like 10, 20 people. It's not like two people. No, it's like a whole bunch of people.
It's a bunch of people that you had no idea.
And
like,
you don't even know them. And then you think that because you don't know the other person, that you're not going to be caught up in that wiretap because they don't have nothing on you. But when your lawyer gives you all the other stuff that's connecting you to this wiretap, then you'll understand how you got caught up. And that's what we call a conspiracy. Mm-hmm. And that we're going to talk about on one of our next sessions, because that needs a whole hour in and of itself. But that's the wiretap. Now, the wiretap has got a little bit complicated because of social media, which is what we're here to talk about, actually. Mm-hmm. So social media has come on the scene, and there's a whole new way of communication, and this whole new way of communication can create an issue for you if you run your mouth via posting photographs. Correct. Don't do that. Don't do that. if you're texting, well, it's not texting. What is iMessaging and DMing?
Yeah,
Oh,
DM.
DMing is what? Because I see iMessage come up on my phone. It's the same thing. Okay, DMing. If you think that your DMs cannot be looked at, you are wrong. They can. What this refers to is what they call a communications warrant intercept. It's a communications data warrant is what this is. And this warrant does not require, you know, that special thing that says we can't do it any other way, so we got to do it that way on the wiretap. Okay, all you need for the communications data warrant is probable cause. That's the thing. If you got probable cause, you can go in. So you could go into I only have Facebook personally. Oh, I have Twitter, Facebook and Twitter. So you could go into the law enforcement once they get the warrant, the communications data warrant, and I'm gonna give you a case here. It's in Ray State. Well, this case kind of tells you the difference between the wiretap and the communications warrant, data warrant. So in this case, they were arguing, the defendant was arguing that in order to get my videos from my social media, you need a wiretap. But the judge ruled in this case, and it's a complicated case, so maybe it's not a good case to refer, but you could try to figure out what it's talking about. But a communication warrant, a communications data warrant gets you everything. Gets you the video, whether you're talking to it or not. They don't have to get no extra warrant because of the voice. So your videos, your DMs, your pictures, if you up there throwing up them gang signs, you probably ought not to do that. If you if some people like, you know, guns, drugs, all that can be credit card fraud schemes and all kinds of stuff. They can get that and use that as a tool to investigate criminal activity. And actually, that can be factored in the application for a warrant, a search, a further search warrant into your house and other things. And if corroborated, it can ultimately lead to your arrest. So, this case that talks about the difference between the communication data warrants and the wiretaps is called NRA State 448 NJ Super 471 AppDiv 2017. So if you put in NRA State and you put in the year 2017 AppDiv in like New Jersey, it'll probably pop up. And it tells you all about the differences between the two. Another thing, some of you might not know, but a lot of your information, everybody, when you get a moment, Google your name and see what pops up. Some of y'all got mug shots. Some of y'all got, the addresses are on there. Some of y'all got the phone numbers on there. It ain't nothing you did, but this information is on the internet. And this is an aside, but when I think about going to trial, I think about this because even though the judge tells the jurors, you can't look anything up on social media, all I know, it's a click away. It's not like back in the old days where the judge says you can't read a newspaper. I mean, you got to make a concerted effort to go out and get a newspaper and read about somebody. But on the computer, all you got to do is click a name and everything comes up. So if there's a case and I'm dealing with a homicide case, okay, so put my client's name in there, boop, boop, boop. There's all the news information about the homicide. It's not the evidence, it's the news's spin. So I got to worry about the jurors, any potential juror who's going to be on my jury panel, seeing that if they decide to Google.
But you wouldn't never know.
You're never going to know.
They're not
and the flip side is, you could, well, it's not really a flip side, but the other side is you can go, if somebody wants to Google, they could go and Google the social media. And if that person, if my client don't have private and it's public and they can see all that, and my client happens to be posting all these different things, okay, well, that's another impression that a potential juror will have against my client. And nobody will know because that juror is never going to say anything because they weren't supposed to be looking in the first place.
Mm-hmm.
So social media is very, very it's really quite
It's not.
it can be quite incriminating, and it's not something that we're on social media, we think it's all fun and games.
You gotta be careful.
Yeah, you gotta think about what you put up there. And people always say, well, future employees may look at it. Okay, that's true too, but there's something more than that, and it could be something that can get you into some trouble. I think that I remember that there was something on the news about somebody, they were doing a video, and they were passing around a gun. And somebody, law enforcement officer tried to lock up somebody who was in the video. And we don't even know if the gun's real or not.
Yeah, that's what I was about to say.
Yeah, but it doesn't mean they're not going to come to your door, and now you got a problem. So you got to be very careful. And now, in terms of the rules of evidence, this is evidence rule 901. So in order to get all that stuff in, the pictures, the DMs, the videos, because there's videos of people. I know we got Nene and Trinity in here. You know they record fights at your school all the time. Those things can be used by law enforcement to arrest the people who start the fight. Now, Trini, you be giggling talking about, there was a fight today at school, but those people can be, those people who get involved in fights and it's posted, they can find themselves having to deal with a legal issue, kids. So, anyway, here's the rule of evidence that allows this stuff in. Now, check this out, because sometimes these rules, they're very, very broad. So this is evidence rule 901. You can Google this too. Put in evidence rule 901. Here's the requirement of authentication. So authentication is it real? Like, is it, is your hat really a whatever the hell it says that it is? Okay.
Or identification.
Or identification. So the requirement of authentication or identification as a condition before precedent, which means a condition before you allowed it into evidence, is satisfied by evidence sufficient to support a finding that the matter is what its proponent claims. Now that don't even make no sense.
Man, they could be more direct. That the way they saying it is.
Check it. Listen. I'm gonna read it again. The requirement of authentication or identification as a condition precedent to admissibility. So the requirement to make sure something is real before it comes into evidence against you is satisfied by evidence sufficient to support a finding that the matter is what its proponent, the person who seeks to get the evidence in against you, that would be the state, claims that it is. So sufficient evidence to support that it is what the police officer says that it is.
And the chances is he gonna say whatever anyway.
He gonna say, I found out through whatever means what the Facebook page for this gentleman is. I saw him. I went in. I saw his picture. I knew it was him. Then I got a warrant to go in because his page was private, or if his page was public, he didn't have to do that. Page was private. I got a warrant.
That's enough to do that.
Well, up until the investigation, there has to be more factors. But this is not the probable cause. This is the authentication. So this is you've already pretty much passed probable cause. This is just them saying this is his page. This is Hamid's page. And the officer has to say, okay, yeah, it's his page because I looked on there. There's pictures of him. He's up there with the gun. That's him right there.
But what if I'm on your page and I've got pictures up there with you too?
Yeah, they might say, oh, this is Cynthia. That's his lawyer. They hang out all the time. As a matter of fact, that I don't want to get to. Okay, so that could happen. That could happen. I mean, they can't introduce nothing when you with your lawyer. There's the attorney-client confidentiality stuff. So, but if it's there, and so basically the rule is not. It doesn't tell you too much. It just basically say that you got to be able to prove that it is what I say it is. That's it.
And then on Instagram, people don't really post up their names.
Yeah, they put different names up there. And that's why they get the warrants to go in and look at it. Like they have it'll start like this. They get the police officer will know your name, your government name, and then try to search you up on Facebook. If they come up with your name, because sometimes the names do pop up, but there's something else attached to the name, like another name, then they'll if it's public, they might see some stuff that you done posted that corresponds with their investigation. Then they go and ask the judge, oh, can we go further into this? Because we went in there, we saw him, this is his, and we see a picture of him holding a gun. And the allegation for our investigation is that he robbed somebody with a gun. So here now you got connections going on and everything.
And I could be having a water gun.
It could be a water gun.
Water gun could open up a whole can.
And that don't stop them from going into your page, and you might DM somebody and say, yeah, you know, that day when we had that gun. Then that comes in. Or the day we robbed that man. Or you could have some language that sounds like that, because they'll bring an expert in and say, oh yeah, he's an expert in this language, and what it really means, you know, I bought a bag of potato chips. What that really means is that I robbed somebody.
Yeah.
Because that happens too, right?
Yeah, that happened to me. They said chop it up is saying you trying to chop up a whole brick.
Oh my God.
Chop it up with you.
So they had you breaking down stuff.
Yeah, you know. Damn, the money ain't adding up to the brick.
But you got another thing stacked against you, even though it was you really was trying to, you know,
a bogus expert at that.
Right, because
they always want to know how you talk. How you talk?
Right. Oh, they got the gang experts. They got the gang experts too, and it's just like none of those experts ever been in a gang.
And they don't really be active.
And they don't hang out. They don't hang out in no gang. They don't know nothing. They only speak to people who are in trouble, for the most part. But that's a different story.
How much time we got? 5 minutes.
5 minutes left in.
I mean, your gums been going.
I've been going the whole time, and nobody interrupt me.
Nah, I've been listening because it's interesting. Yeah.
Okay, so United States v. Brown. Brown is the federal standard for the admission of into evidence of anything really, but this is talks about the authentication that I was just telling you about, and then I had like 4 cases that referenced people who said things on social media that led to their convictions. So 4 separate cases.
You personally had them in yourself?
No, these are not my cases. No, I'm not discussing any of my cases on this platform.
Yeah.
Stop! Don't even say that.
Nah, that's what.
Because there's attorney-client confidentiality. So I will be discussing nothing having to do with anything regarding my clients. Sheesh. These are published cases. Some of them are published, or some of them are unpublished. But they're all cases that are on the internet. State v. Hannah. State v. Hannah. This is 448 NJ Super 78. The year is 2016. This is the case where there were tweets that were admitted into evidence. This was a situation where
could they do
this is kind of funny.
Could they do your tweets? Could they do your
Snap.
No.
They could do your snap.
Yeah, they could do your snap, but your emails.
Emails too.
Yeah.
Everything.
Anything concerning social communications.
Internet file. Yep.
So listen, this case is where there was a ex-girlfriend and a present girlfriend and a boyfriend. The ex-girlfriend supposedly hit the present girlfriend in the face with a shoe. She had to get stitches. So the ex-girlfriend had to go to municipal court. I believe this was municipal court, maybe not, but had to go to court for assault, some type of assault. The ex-girlfriend said, no, I didn't, none of that happened. It didn't happen. I don't know what they're talking about. And so now there was a tweet. I guess this is Twitter. There was a tweet exchange between the ex-girlfriend and the present girlfriend, and the ex-girlfriend says something about I shouldn't have to be going back and forth with you. Shoot to your face, bitch. That came in against her because now.
Oh, that's like an incriminating statement or something?
Shoot to your face, bitch.
But you gotta.
How does anybody else know about this situation if it's not you? Why would you say shoot to your face?
You think that's enough for them to convict them?
Well, I can tell you what the judge said. Said that she was the defendant was charged with aggravated assault, but they downgraded to simple assault, disorderly persons offense. And the court said yes. The court said that was that tweet was confirmation of identification, because who else other than the person that was there involved in that would know to say that?
She could have told one of her friends.
She says, no need for me to keep responding to your stupid, unhappy, fake, mole-having ass. How you cringe in a corner with a shoe to your face, bitch. And she put it on her Twitter handle. They authenticated that. There was testimony from the new girlfriend that they had to exchange. We was going back and forth, and the court ordered that was enough of an authentication to allow that tweet to come into evidence as against her. And just trying to find the language.
Boy, this thing getting worse. Pretty soon you can't even walk down the street. Switch the wrong way.
Well, you ought not to. Do you think you ought to be on the darn social media saying stuff like that after you done hit somebody in the shoe with in the face with a shoe?
I'm not talking about just that. The overall, like the whole topic in itself. But everything that was.
Okay, so here it is. Authenticity can be established by direct proof, such as testimony by the author admitting that they authored something. But direct proof is not required. You know, like in trial, me and you had the trial together, that direct evidence and circumstantial evidence. Okay, direct evidence is you saying, okay, yeah, this is my tweet. They're saying it doesn't have to be direct proof. A prima facie showing may be made circumstantially. So such circumstantial proof may include demonstrating that the statement divulged intimate knowledge of information that one would only expect the person alleged to have been the writer to know or to have participated in. So he says here the tweet contains several details, including shoot to your face, information that one would expect only a participant in the fight to have known. So that was it. That was enough. So, I just talked the whole damn show. I apologize. Sorry. And so we'll come back because I want to share with you these other cases that we had. They're very interesting. One lady showed pictures of money on her bed on social media, and 10 minutes later she was robbed in her apartment. So we got to talk about that. And then after we finish up with this, we're going to talk about the whole concept of conspiracy and how that pertains to whether or not someone can be labeled a snitch or not a snitch. That's our next topic of discussion. And then I'll let Hamid talk some more because I really did have a mouthful of the law to share. So we need to put some experiences in.
You don't forget the Miranda.
We're gonna fade to black. Y'all wanna listen to some music while we go? Is this new music, Cream? Yeah. Okay. See y'all later. Listen to the music.
First thing.
I let you panic and think alive when you talk. I don't run like some nigga cut through the phone. Well, I'm looking down like a giant.
Well, that was deep.
No, I don't do this attention. No,
I didn't realize it would be that much on the fucking mall.
they take me never too close to time. Niggas with cushy at 4.
Took
Wow,
over.
had to go running up, running up, had to go running up. Like
I like it.
You have to give you your session next
No,
time.
I know I was not. I liked it. It was. I had
It was
questions.
informational, but yeah, they do use that inside